Hello and welcome back to Bookish. I decided to use my video today to address the issue of the Supreme Court's decision recently to overturn Roe versus Wade and why I think that is an inherently flawed decision based on what I consider to be an absolutely silly and ridiculous idea. Before going any further, you need to know I'm not a lawyer. I certainly don't have the legal expertise of the Supreme Court justices, but I will be honest with you, I think oftentimes that expertise, Supreme Court justices use that in an attempt to overawe ordinary people into believing that they understand something better than an ordinary person could because they have some, knowledge that the rest of us don't. And certainly, Justice Alito in his decision attempted to do that by bringing in all kinds of historical fact and, citing English common law and the pronouncement of judges here in what would become the United States from the 1660s, including, by the way, one judge who presided over witch trials is actually quoted in Justice Alito's decision. But I think they do that in an attempt to overawe the rest of us into believing that there are incredibly complex issues at hand here that the rest of us can't possibly understand and that they understand better. And I really think in the case of Roe, that's absolutely not true. Now, I know this is a controversial topic. I know that my channel is a booktube channel. And so I would hope that if any of you are going to be offended by anything I have to say here, or just don't like my political content, you'll just skip this video, and that'll be fine with me. But from the rest of you, I do look forward to your comments one way or the other in the comment section down below, and I will engage with you there. I can't promise you that engagement will always be something that you enjoy. So to kind of cut through and kind of look at this issue and the way in which the Supreme Court overturned Roe versus Wade and the way in which I think they were completely wrong to do so, you kind of have to look at and remember something about the laws here in the United States. Number one, the Constitution is the law of the land. No law can be made in the United States which contradicts the Constitution. But the Constitution is kind of almost intentionally vague. And it's a really very short document for a document that's been governing a country for, more than 230 years or so. 250 years. It's a really relatively short document. And it was written in haste. It was written by a group of people who felt forced to compromise to get something done. It was written during a time of crisis in which that group of people believed that the United States, under the Articles of Confederation, was going to come apart and was going to fail. And it was not a document that was ever going to make everybody happy. That's something to keep in mind. Additionally, the United States does have a common law system. In other words, courts make decisions based on precedent. That is, laws that come before and decisions made by judges that come before. That's oftentimes the justification for the decisions they make, which is why Justice Alito felt compelled, and I'll say this again because it's so ridiculous, to cite the opinion about abortion of a doctor who oversaw witch trials in which there were convictions. So we do have that kind of common law system, and so precedent here is supposed to matter. The first issue I have, though, with the Supreme Court in this decision is just an issue I have with conservative justices and judges in general, and that is they all claim to be originalists. In other words, what they are interested in is interpreting the Constitution in the way in which the framers of the Constitution would have interpreted it. In other words, they're looking at this kind of idea of original intent. What did the framers mean? How can we figure out what the framers meant? This is why they oftentimes resort to, combing through historical efforts to comb through the writings and the publications of members of the founding generation here in the United States of America, looking for evidence that they can use to cite that this is what these people thought. Well, I think on the face of it, interpreting laws in 2022 based on the ideas of men who we all know had racist ideas, many of whom owned slaves, who didn't believe that women were equal in the first place, interpreting our laws today based on the ideas of people who lived in 1787, wealthy men, many of them slave owners, who lived in 1787, is an inherently ridiculous notion. It just is. And I'll be honest with you, and this is reportedly what I'm going to talk about, it is such a ridiculous notion that even I think the framers themselves would have found it to be a completely ridiculous notion. Why should a precedent set in a statement by a judge in 1690 carry more weight than the precedent set by the justices who decided the Roe case in 1973? You know, why in our modern world is one way more than the other? And I would argue, you know, as somebody who is an American historian, it's because of the way that which we teach this almost religious reverence for the founding fathers, that somehow they were greater than we are, and therefore their ideas the ones we should follow because they're these almost godlike creatures. Well, that is an inherently flawed idea in my opinion. And so from the very beginning, I think original intent is just an awful kind of thing to base congressional or to base Supreme Court decisions on. Not that those things should be completely ignored, but to make that the organizing principle of your judicial philosophy seems to me to be completely wrong-headed. Okay, that there needs to be more of a balance. That we have to view the Constitution differently today than it was viewed by the people who wrote it in haste as a bundle of compromises in an attempt to save what they thought was the founding of the United States of America. I'm not sure that the intent of the framers of the Constitution should matter more than the opinions, or carry more weight than the opinions of Supreme Court justices in 1973 who made the decision in Roe. And yet, our conservative Supreme Court thinks that that's exactly true. So I'm going to take that on its own terms. I'm going to take original intent on its own terms. I think it's silly. I don't think that should be the overarching way in which Supreme Court justices look to make decisions. I don't think it's always necessary to comb through old documents to find out, what the thinking of the time was, because I think, in all honesty, what's more relevant is the thinking of our times now. And I think the framers would have agreed with that. So I'm going to stick with the idea of original intent and take on the decision the Supreme Court made to overturn Roe based on the concept of original intent. Well, there are two parts of this original intent thing I want to address, and both, or neither, actually requires me to go really any further than the two most important founding documents in American history, the Declaration of Independence, which I'll talk about very briefly, and the Constitution, which I'll talk about here in a little bit more detail. But I think it is clear from both those documents that the original intent of the founding fathers, the original intent of the framers of the Constitution, was to create governments that were flexible and could change to meet the needs of the people moving forward. As a matter of fact, I more or less just paraphrased Thomas Jefferson from the Declaration of Independence, who basically said it was the obligation of people when a government or a law or something government was doing was not meeting the needs of the people, it was their obligation to change it. Okay, so we have built into the Declaration of Independence this original intent idea that governments have to be flexible and change with the times and needs of the people. That is reflected in the Constitution itself. Now, you should know the Declaration of Independence has no weight as law other than this original intent way. The Constitution is the law of the land. The Constitution itself reflects this belief in change. Okay? The Constitution basically is made up of 7 articles. The 7th article is about nothing but how to change the Constitution. So tell me the framers of the Constitution didn't have in mind as change as part of their intent, and then explain to me why they had this whole section of the Constitution which is about nothing other than how to change the actual Constitution. These are men who realized that the government of the United States would have to change, and they built in a system for changing the founding document of the United States, which we've amended the Constitution 27 times to meet our needs. We've done really important things. Outlaw slavery, extend the rights of citizens to everybody in the United States, protect people from state governments, which, by the way, this Supreme Court apparently doesn't think it's important. Extend the right to vote to African American men and to women, etc. We've done really important things in amending the Constitution to make it suit our needs, to have it change and have our government change as we change. This is clearly part of the intent of the framers of the Constitution. Okay, you don't have to comb through some book in 1660 about common law or some decision made in England in the, 1720s. It's right there in the Constitution that our government has to change as we change. But there's more than that. Article 1, Section 8, Clause 18 of the United States Constitution is called the Necessary and Proper Clause. And essentially what it says is that Congress has the power to do whatever is necessary and proper to carry out its other powers. Now, Article 1, Section 8 lists 17 specific powers of Congress. You should know the framers of the Constitution believe that Congress should have most of the power of government and not the President. That's another way in which the Constitution has changed, by the way, that we give far more power than we should, by the way, to the President of the United States. But Article 1, Section 8, Clause 18, the Necessary and Proper Clause, sometimes called the Elastic Clause, is not an accident. This is not, something the framers just threw in. They realized that they couldn't possibly think of everything the United States government needed to be able to do. Meeting in Philadelphia in 1787 in September and trying to rush to create this document. So they basically created this way for the United States government to adapt and change to meet the needs of the people moving forward. In other words, this is more proof that one of the original intents of the framers of the Constitution was that the government had to change to meet the needs of the people. And then the third example of that actually comes from the Bill of Rights, which is not a part of the original Constitution. That's why it's an amendment. It was added more or less in 1789 as soon as the new government got together. And that amendment, and this is the amendment which really is at the heart of the decision, of the Roe decision, and then the Supreme Court's recent decision to overthrow it, and that is the Ninth Amendment. The Ninth Amendment contains your unenumerated rights, and essentially what it says is that you have more rights that are listed in the Constitution. Now tell me James Madison, who is the primary author of the Bill of Rights, wasn't creating an amendment for the sole purpose of allowing our government to extend more rights than he and the government at the time could think of in 1789 to extend to the American people. He intentionally says we have more rights than are listed here. So to me, it's completely disingenuous, number one, for the Supreme Court to say they can find no right to an abortion in the Constitution when the Ninth Amendment is right there. Okay, now what they say is, well, Madison didn't mean abortion when he wrote the Ninth Amendment because all these other things mean that Madison would have been against abortion. They're missing the point of the Ninth Amendment. The Ninth Amendment is so that we can extend rights, we can have more rights, we can adapt our rights moving forward in ways that people like Madison might not have been able to imagine, might not have been able to think about. It is there for that specific purpose, for change. So part of the original intent of the framers is that our government be allowed to change. They did not want to fix the Constitution, as it were, in amber and preserve it in their thinking and expect us to govern ourselves based on 1787 ideas forever. They intended for us to be able to change it. Part of the intent of the framers is that we change the government to meet our needs. So if that's part of the intent, then this whole idea that we have to stick to what the framers thought in 1787 is exposed, I think, as ridiculous. And I think the Constitution has those ideas in it. So then how do we apply those ideas specifically to abortion? Let's say you accept my idea that the framers would have wanted us to be able to change and adapt and expand the powers of government and our own rights as individuals. How do we apply that to abortion? Isn't abortion, an issue in which, there's clearly a moral thing that the framers would have been against? And I'm going to tell you up front that that doesn't matter. Because what the framers also put in and what the Constitution also contains is the preamble. The preamble, I mentioned this in a video before, the preamble is a statement of intent. It is literally the framers of the Constitution saying, here's why we created the United States Constitution, here's why we're creating this new government, here's what we want this government to be able to do. Not just right now, but into the future. And I can prove that by once again reciting the preamble of the Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and ensure the blessings of liberty to ourselves and our posterity, meaning future generations, do ordain and establish this Constitution of the United States of America. So what the framers are saying in the preamble is that whatever is necessary to do things like secure the blessings of liberty, the United States government should have the power to do. So if we apply that idea to Roe and we think about the issue the Supreme Court was deciding in 1973, in Roe. In Roe, the Supreme Court looked at the Constitution and they said, well, the Ninth Amendment guarantees us more rights than are listed. So we don't have to just stick to what are listed in the Bill of Rights or elsewhere in the Constitution. We can look at other areas, and the right that was focused on in the decision the Supreme Court made in Roe was the right to privacy. Isn't there an inherent constitutional right to privacy? Isn't this implied by other things in the Constitution? And in 1973, the Supreme Court said yes, there is a constitutional right to privacy. They could find justification for a constitutional right to privacy which would protect a woman's decisions, medical decisions that she made. And they essentially said in the first trimester, the woman's right to privacy, which comes from the Ninth Amendment, is extended to all citizens in all the states by the 14th Amendment. At some point, in the first trimester, the woman's right to privacy is absolute. It is the right. That there is constitutional validation for that, and they use the Ninth Amendment as proof. And really what they're saying is that a woman has a right to privacy to make decisions over her own body because that's part of securing the blessings of liberty. Okay, they may not have said it in Roe, but in the preamble, our government's supposed to secure the blessings of liberty. And the right to bodily autonomy is one of the blessings of liberty. Not to mention that one of the things that came from abortion is that it freed women from unwanted pregnancies. It freed them up to become to have more educational opportunities, more economic opportunities, more opportunities for self-fulfillment because they controlled their bodies and made decisions for themselves, and that decision making is part of the blessings of liberty. So there's no need to comb through all this old stuff, not in every case. And there's no reason for us to put more emphasis on what the framers thought or the people who came before the framers thought in every case. And this is certainly one of those. In overturning Roe, the Supreme Court overturned 50 years of precedent. They overturned 50 years of law based on their belief that the framers never would have extended the right of abortion to women, when the framers themselves intended for us to change the government and adapt our rights to meet the needs of people today. Anyway, these are my thoughts about why the Supreme Court decision in Roe versus Wade was completely wrong and completely wrong-headed. As always, these are just my opinions. I'm certainly not an expert, but I do think that sometimes expertise literally means that Supreme Court justices can't see the forest for all the trees. I do think this is an example of that. Anyway, I look forward to your comments in the comment section below. As always, thank you for watching.